So the Fifth Circuit Court of Appeals just ruled in the Texas Suppressor Freedom case, which aims to remove the NFA and ATF's regulation of suppressors made in Texas. So let's talk about what just happened. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They have great supplements. They've helped me along with my health journey. But one of the other really cool things about 1st Phorm is that they are super pro 2A, they are pro America, and they believe in what we do here on the channel. So if you want to get amazing supplements and support a company that believes in our freedoms, check out 1st Phorm. You can see them using the links down below in the detail section and then also in the pinned comment. So thank you again to 1st Phorm for sponsoring and supporting this 2A content. Now, as I mentioned in this intro, we have some big news coming out of the state of Texas and coming out of the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals reviewed and heard the issue involving the state of Texas and their suppressor freedom case. And this has to do with a law passed in the state of Texas, which aimed to eliminate the NFA and ATF's regulation of suppressors that are made in the state of Texas and that remain in the state of Texas. This case that we're going to be talking about is called Paxton versus Dettelbach, and it's a case we've been covering closely, and now we have a ruling from the Fifth Circuit. And I'll just be upfront with you guys, it is not great news coming out of the Fifth Circuit. The Fifth Circuit Court of Appeals has sided with the lower court, and they agreed that the plaintiffs here in this case lack standing, and therefore they upheld what the lower court said. Now, you may recall that this was a very important case that was decided by a district court judge back, I believe, in last July on cross motions for summary judgment. A federal district court issued an order granting the ATF's motion for a summary judgment. Now, if you're not aware of what a motion for summary judgment is, it's just simply an early mechanism for a court to resolve a case, and that's what happened here. And ultimately, the judge believed that the plaintiffs here in this case lacked standing to bring the lawsuit, and therefore it ruled in favor of the ATF. Now, the court also found that the state of Texas could not stand in the place of its residents to sue the government to essentially stop this application of the NFA towards made in Texas suppressors. Now, after that, Texas appealed that ruling to the Fifth Circuit Court of Appeals, and it went in front of a 3-judge panel. But the main argument in this appeal was whether or not the plaintiffs there, the individual plaintiffs and the state of Texas, whether or not they had standing to have this case proceed forward. Now, the 3 judges that reviewed and decided this case are Edith H. Jones. She is a Reagan appointee. Edith Brown Clement, and she is a Bush appointee, and then Corey Wilson, and he is a Trump appointee. So those are the 3 judges that heard this case and have now ruled in this issue. Now, the opinion of the court was issued by Edith Brown Clement, again, the Bush appointee, but all 3 judges agreed in this decision. So there were no dissents, everybody was on board, and ultimately what they found is that the individual plaintiffs here, that these people who brought this lawsuit, that they lack standing, and so the lower court's decision was upheld, and the ATF has for now won this case. They also found that the state of Texas lacks standing as well. So we're going to look at the 2 main reasons why this court found that the individual plaintiffs here lack standing, and then we're going to talk about how this case really is not dead at all. Likely this is just going to move in a new phase of this lawsuit, and maybe there's even going to be an appeal up to the en banc panel in the Fifth Circuit to review what this 3-judge panel just said. The 2 main reasons that the court here found that the plaintiffs lack standing was first because they said that their declarations were insufficient to show that there was either a serious intent to engage in this conduct, and then also they said that there was no time period of the conduct that was alleged in the declaration, and those 2 main issues ultimately showed in the court's eyes that there was no standing in this case. So the court here stated that for 2 reasons, we find that these declarations are insufficient to establish a serious intention to engage in conduct prescribed by the law. First, the declarations do not state any intention to engage in conduct prescribed by the law. Rather, the declarations state only that the individual's plaintiffs intend to personally manufacture a firearm suppressor for their own non-commercial personal use. But as the federal government points out, the statutes at issue do not prohibit the individual plaintiffs from making a firearm suppressor. Rather, they only prohibit making a firearm suppressor without complying with the applicable procedures and requirements, i.e., applying for approval, paying the requisite tax, registering the suppressor, and labeling it with a serial number. Here, the opposite is true. The individual plaintiffs have only stated an intent to personally manufacture a firearm suppressor, but say nothing about whether they intend to personally manufacture a firearm suppressor without applying for the government approval, and they make no claim that they are statutorily ineligible for such approval. So they have failed to show that their intended conduct is within the scope of what the federal law prohibits and therefore lack standing to bring their pre-enforcement challenge. So here what the court is pointing to is that they did not show, or they at least did not allege, that they intend to actually make these items without going through the process. And this is kind of one of those things where the court is kind of nitpicking at how things were alleged. What they're claiming here is that the plaintiffs allege that, yes, they intend to make suppressors, and they intend to make suppressors in Texas. And the court says, well, that's all good and dandy, but you also have to allege that you intend to make these suppressors in Texas and then not go through the process. And because the plaintiffs did not allege that they do not intend to go through the NFA's process, the court here has found issue with these declarations, and based on that, they also say that there is no standing. Now, the second issue they found is, second, the declarations lack the necessary detail to establish that the individual plaintiff's professed intent to make a silencer is sufficiently serious to render their feared injury imminent rather than merely speculative or hypothetical. So here what the court is kind of nitpicking at again is how things were alleged in the declaration of these individual plaintiffs. They claim that in these declarations, the plaintiffs did not sufficiently allege that they intend to make these suppressors by any specified time period. Instead, there's just this hypothetical, sometime in the future, we intend to make these suppressors. And what the court wants here is a little bit more of a clear guideline about what these plaintiffs intend to do, by when they intend to do it, and maybe what process or what steps they're going to take. They also then point out other 2A cases like the Antonio case out of New York about, concealed carry and wanting to concealed carry at specific locations that were deemed sensitive locations. And they said there that the Second Circuit found standing in the Antonio case because the plaintiffs alleged that they intended to carry at these locations on certain days or certain time periods. And because of that, more express, hey, I'm going to carry at this specific location at this specific time, that cured the standing issue. Here they're saying that they did not do this in the Paxton case, even though this has to do with making suppressors. They would have to actually outline, hey, when do we intend to do this? We intend to do this by this time period. These are the items we've bought. This is the item we're going to make. This is how serious we are about this. And the court here is just simply saying that the plaintiffs did not allege enough in their declarations. Now, one of the other things that they said later on in this decision was that they know that there is this kind of tightrope that people have to walk about, of course, violating the law. You can't go so far overboard where you're actually violating the federal law, where you're already making these items. But then there's this other side of the spectrum where they say these plaintiffs are, where there's just simply this hypothetical, sometime in the future, we intend to maybe engage in some type of conduct. Now, I don't necessarily agree with this decision, but that's what the 3-judge panel here in the Fifth Circuit is saying, that they would need to allege more in their declarations to show standing. And based on that, the 3-judge panel here ruled in favor of the ATF. They upheld the dismissal, the motion for summary judgment that happened in the lower court. Now, you may be asking, okay, where does this case go from here? Simply what could happen is if the state of Texas wants, or these individual plaintiffs want, they could just cure up some of these issues in their declarations in this lawsuit and then refile, resubmit to cure some of these standing issues, so this case proceeds forward. One of the other things, of course, they can do is they can, of course, appeal what this 3-judge panel said. They can try to take it en banc in the Fifth Circuit. I find that unlikely, though, because you already had 3 judges here on this panel, very favorable, draw of panel. You had Trump appointees, Bush appointees, and Reagan appointees. A good draw in the Fifth Circuit, and all of them still found standing issues in this case. I think that maybe they could file for an en banc review, but it still would probably go the same way. It would be best for the plaintiffs here to just cure some of these declaration issues, have a little bit more concrete declarations, cure up some of these issues that the Fifth Circuit want, and then resubmit it. So that's where this case currently stands. Of course, not news that we wanted to hear. We all kind of speculated that's the way this was going to go, especially standing issues. It's just a way for a court to punt this issue when they don't want to address it. But we're going to keep our eyes on this to see what the state of Texas wants to do. So of course, as we get more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and don't forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.